What are some examples of fallacies of relevance? Have you ever heard an argument that just didn't seem to connect? That's where fallacies of relevance come into play. These fallacies occur when the reasons given do not logically support the conclusion. They can be persuasive but often distract from the real issue. In the context of law school admission, test preparation, and logical reasoning, understanding these fallacies is essential. Let's look at some common examples. First up is the ad hominem fallacy. This happens when someone attacks the person making the argument instead of the argument itself. For instance, if a lawyer dismisses a witness's testimony because of their background rather than the evidence, that's an ad hominem attack. Next, we have the appeal to pity. This fallacy tries to gain support by evoking sympathy rather than presenting relevant facts. Imagine a defendant arguing for leniency because they faced hardships, ignoring the actual evidence against them. Another example is the appeal to force. This involves using threats to persuade someone instead of logical reasoning. For instance, if a lawyer suggests a judge should rule a certain way out of fear of backlash, that's an appeal to force. Then there is the appeal to ignorance. This fallacy assumes something is true simply because it hasn't been proven false. In legal terms, it might look like arguing that a defendant is guilty because there's no proof of innocence. The straw man fallacy misrepresents an opponent's argument to make it easier to attack. For example, if one side simplifies or exaggerates the other's legal position to refute it more easily, that's a straw man tactic. Another common fallacy is the red herring. This occurs when irrelevant information is introduced to divert attention from the main issue. For example, discussing a party's unrelated personal life to distract from the legal question at hand is a red herring. Ignoratio Elenchi, or irrelevant conclusion, presents an argument that may be valid but does not address the actual issue being debated. For instance, arguing about the morality of an action when the legal question is about the law itself falls into this category. The appeal to popularity suggests that a claim is true simply because many people believe it. This is not a strong basis for an argument, especially in legal reasoning. Lastly, the appeal to authority relies on the opinion of someone who may not be an expert in the relevant field. Just because a famous person says something does not make it true in a legal context. Recognizing these fallacies is vital for law students and anyone preparing for the law school admission test. It helps in critically evaluating arguments and constructing strong, logical cases. Understanding these examples can sharpen your reasoning skills and prepare you for the challenges ahead.